So in South Africa, litigation, the common fighting it out in court, has really outpriced itself for many South Africans, especially entrepreneurs. Not only has it become very expensive, but it's also become a lengthy process. I mean, at the moment, we're waiting up to 3 years for trial dates. So there's been this trend to resolve disputes in an alternative way, and specifically in South Africa, there's two ways. It's A, via mediation, or secondly, what we call arbitration. Both involve an independent third party, referee, for lack of a better word, who really gets those two parties together, whether it's shareholders or directors that are involved in a dispute, and tries to resolve that dispute. In mediation, the mediator will listen to both sides. They'll put forward a number of suggestions to try and resolve the dispute. But the mediator's role really is to try and facilitate the problem solving and for those two parties to reach an agreement by themselves. The mediator can't be imposing a decision upon those shareholders or those directors. The arbitration takes it a step further, where the arbitrator is specifically mandated with powers to make a decision, and it really equates itself to a judge in a courtroom who will listen to both sides and will say, right, I've heard all the evidence, I've weighed it all up, and this is the decision I've made. And that decision will then be binding upon the participants involved in arbitration. The commonality between mediation and arbitration is that the mediator and arbitrator need to be paid, whereas in the court system, we don't pay for judges. Those are government services. So there is a cost aspect associated with the process. Mediation, attorneys aren't allowed to be present, whereas arbitration, participants will be allowed to have legal representation. Your mediators, arbitrators, generally the fees can range anywhere from 700 Rand up to probably about 2,500 Rand per hour. And it's based on the number of sessions. So typically in mediation you'd have about 5 sessions, and if by that 5th session you haven't reached an agreement, the mediator will call it. They'll say that unfortunately mediation has been unsuccessful, and the parties will then have to pursue the matter in court. So if you're looking at about 5 sessions, it would be based, each session is about 2.5 hours long, and it would be charged on that hourly rate of the suitable professional that is appointed as the mediator. Arbitration is a little bit more expensive. It is more time consuming because each individual is given a chance to represent the case. They might have attorneys, paperwork is submitted as evidence. So those costs do become significantly higher than mediation, but generally the costs are split 50-50. And the advantage of alternative dispute resolution is it really does go a step further in saving these business relationships that have broken down. Whereas the court system generally tends to polarize individuals. It's an all or nothing approach, and it really doesn't take into account the bigger picture of relationships at stake. Your biggest topics at the moment is disagreements between directors, typically regarding the management of businesses. So contracts, what's coming up often is that directors are being unauthorized in the conduct. So they're making decisions on behalf of the business which they're not authorized to do. Shareholders aren't then agreeing with those decisions, and that typically then leads to a dispute between your role players in a company. It can go a step further. You can have disputes with your service providers, suppliers, and that also then lends itself to mediation or arbitration. Just in terms of your alternative dispute resolution, it's all good and well to say having your shareholders agreement that if there's a dispute it will go to arbitration. But it's really important that it goes a step further and says what happens if you can't agree who the arbitrator is going to be. So in our shareholders agreements, it's really wise to put in that if the shareholders or the directors cannot agree, that if it's a legal question, that it be arbitrated by an attorney with not less than 10 years experience or an advocate, or if it's an accounting question, that it be dealt with by a chartered accountant with not less than 10 years experience. And if the parties still can't agree on that, then there should be provision in agreements that then your law societies or your arbitration societies of South Africa then appoint the arbitrator.